We now turn to the second case on this morning's docket. That is case number 105148, State of Kansas v. Leonard Charles Sr.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Leonard Charles, and I request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, my intended remarks today are about primarily issue 1 and 5, with just one comment on issue 4, and also to answer whatever other questions the court have about other issues. My only remark about issue 4, which had to do in this case with the Court of Appeals holding that they could not reach an issue about an failure to give a limiting instruction in this case because Mr. Charles had not objected to certain prior bad act evidence, relying on Whetstone, which I think this court knows. This court has reversed Whetstone, and I think you know that that applies to this case because you cited Mr. Charles' Court of Appeals case in that decision. So I don't have anything else to remark about that. Issue 1 in this case has to do with what the Court of Appeals agreed was an erroneous lesser-included offense instruction. And this was a subtle issue in some ways, and one that I perhaps wasn't very articulate about in my brief. So I'm hoping to use this opportunity to articulate better why the erroneous instruction, what the Court of Appeals found was an erroneous instruction, mattered in this case. Mr. Charles was charged in this case with intentional aggravated battery using a deadly weapon. Judge Kaufman gave a lesser-included offense instruction for reckless aggravated battery using a deadly weapon or in a manner in which great bodily harm or death could be inflicted, and also gave then simple battery as a lesser of that. So the Court of Appeals agreed, we obviously think correctly, that the instruction was improper because Mr. Charles was never charged with aggravated battery for an act committed in a manner in which great bodily harm or death could be inflicted. And so this instruction expanded the possible theories that the state could use to get aggravated battery in this case. And following this court's pronouncements in Troutloff and other cases like that, it's improper for the state to be able to expand through jury instructions the ways that a defendant can be convicted. So the Court of Appeals agreed that the lesser-included offense instruction here was erroneous. The Court of Appeals, we think, incorrectly found, though, that it was harmless. And I guess I needed to just take a minute to explain why I think that that conclusion was improper.
More specifically, that it didn't reach the clearly erroneous level, right?
Right.
Okay.
Which I think particularly in a case like this, I don't know what that means. When I look at Troutloff, it's at the end of the day, are you confident that the jury didn't possibly use that improperly expanded theory? I think that was the test you used in Troutloff. And so I don't know to what difference that makes. I think under any test, we meet that test and reversal is required. You shouldn't have any confidence in the outcome of this case, that's for sure, on this count. Mr. Charles was charged with intentional battery with a deadly weapon. Judge Kaufman gave a lesser for reckless battery with a deadly weapon or in a manner whereby great bodily harm could be inflicted. The jury in this case convicted Mr. Charles of the lesser included offense. So what do we know? What do we know from that verdict? We know that one or more of the jurors had a reasonable doubt whether Mr. Charles acted intentionally or whether he used a deadly weapon or both. We know that from this verdict. But the improper jury instruction let the state off the burden of having to prove deadly weapon. If there was a juror who said, I have a reasonable doubt whether Mr. Charles was using this car as a deadly weapon, they didn't have to make that decision when they got to the lesser. They could say, well, I still have that reasonable doubt, but I don't have to deal with that reasonable doubt now because I have an alternative way of convicting. Even though I have a reasonable doubt whether or not Mr. Charles used this car as a deadly weapon, I'm still able to convict under the instructions that judge gave me. And to us, that's where the real error and the harm in this case is. And it's exacerbated when we consider the nature of the finding of using a car as a deadly weapon. And this is articulated better, I think, in the second issue, where we're sort of arguing that it's a logical inconsistency to recklessly use a car as a deadly weapon. Because the definition of a deadly weapon is using something in a manner calculated or likely to cause death. That's what a deadly weapon is. You have to, so it's unusual maybe, but I think correct to say, can a car be used as a deadly weapon?
Doesn't your logical inconsistency argument break down when we consider the likely in what you just said as opposed to calculated? I understand it as to calculated. I mean, it's hard to recklessly calculate. They're just
we think
logically
hard to recklessly calculate.
Right. But what about recklessly and likely? Don't those fit together?
No, in that it's closer, but I think no, in that it's still, I mean, I can't do something that I know is likely to cause harm recklessly, I think. Even if I'm wrong about that, Justice Breyer, though.
But it doesn't require you to know that it's likely, it just has to be likely, right?
Has to be,
And that's the part where I think
the
you break
definition of reckless, you'd have to, break that down and say, do I have to know that it's likely to cause something in order for my actions to be reckless? And if that's not true, then it's still logically inconsistent. And I think it is.
Say that again, please.
That is to say, the question here is, what does it require to do reckless conduct? And is that satisfied by, or I'm sorry, it's the other way around. If I'm doing something that's, I think is likely, no, you're confusing. I may have to do a chart on this and submit it later in a 609 letter. We have to lay side by side the definition of reckless behavior along with
Which is know or should have known, right?
No, or should have.
conscious disregard of, know or should have known, and likely.
Should have known doesn't
That
require
is-
actual knowledge.
That is,
That's-
if I commit something that I think is likely to do a certain, have a certain result,
So-
is that reckless?
So why can't driving at high speeds on snow-packed roads be a knowing disregard of something that is likely to cause bodily or result in death?
Again, I needed to parse the definition of reckless a little bit more. I want to get a little bit past this to say it doesn't matter, because the point is this is a very different analysis, isn't it? This is a very different calculus that we're entering into. So even if you disagree with me about if it's logically impossible to do this, at least it must be the case that it's a different analysis to do this than to make the simple determination that it doesn't even have to be likely to cause bodily harm or death. That's not what the test is for aggravated battery under that theory, right? It just has to, it says could be. It doesn't have to be likely. It doesn't even have to be probable. Just could cause bodily harm or death. And so that's my point at the end of the day, is that those are very different analyses, and that it is easier for a jury to convict, assuming that they do have some reasonable doubt about whether Mr. Charles was using the car as a deadly weapon in this case, the specific circumstances. That calculus, this whole discussion that we've had, goes out the window because of the erroneous lesser-included offense instruction in this case. This is a great, interesting discussion. This jury didn't have to have it because of the erroneous lesser-included offense instruction in this case. That's what we think the harm is of this lesser-included offense. Just to touch on issue 5, which has to do with whether or not it is appropriate for Mr. Charles to be required to register as an offender based on a judicial finding that he used a deadly weapon. A sort of interesting corollary here. And I don't have a lot to add other than to note the Court of Appeals followed Chambers, and Chambers followed cases from this court like Carr and Garcia and Beasley, cases that talked about whether or not Apprendi applied to a finding that allowed for an upward dispositional departure, allowed a district judge to sentence somebody to prison when otherwise probation was called for. Certainly there have been developments in the United States Supreme Court law that I think call Carr and Garcia and Beasley into question. But even if they're still right, they're distinguishable from the issue we're dealing with here. If Carr and Beasley and Garcia are correct, it's on a theory that a person gets a certain prison sentence in every guidelines case, and that's certainly true. You get a prison sentence in every guidelines case. The question of whether or not you get probation or not has to do maybe with how you serve that prison sentence, whether it's in prison or through probation or something like that. That might be an argument. I'm not adopting that argument. Please don't hear me adopting that argument. I'm simply suggesting that's a possible distinction. That's not what we're talking about today. The punishment for somebody that is required to register as an offender is additional and greater to anything that is set forth by the jury verdict and justified by the jury verdict in this case. Without the finding by the judge in this case, Mr. Charles is not required to register as an offender. And this court has found that registration is punishment, and that's correct. It is. It puts a stigma and responsibilities and potential.
Referring to Myers?
Yes, Your Honor.
We said registration was not punishment, but public notification was punishment.
And public notification is part of Mr. Charles' offender registration requirements. It's part of what he has to do and is subject to. The stigma.
How does Myers retain viability after Smith versus Doe in the U.S. Supreme Court?
I think there's twofold answers. One, the idea that the stigma that attaches to that public notice is still good law as far as the statute in Kansas.
But the U.S. Supreme Court said no. That the Alaska statute, even though they posted on the internet, that didn't render it punishment.
Well, this court construes our own statute in that regard. The second part of it is, if we're going to do that analysis, then we have to completely redo the analysis with regard to all of the onerous effects of registration that, for example, exist in Kansas, which are substantially more than the statute in the Alaska case, and which I haven't briefed. That's not been a big part of the issue here. I certainly wrote this on the idea that Myers said that this is punishment. I suppose if the court...
This is a little different than the sex offense cases where you just had to fit the statutory definition of a sexually violent crime. Here we have to have the sentencing court make a factual determination that triggers what is a civil remedy.
That's right. I mean, this would be a different case. Yeah, that's right. If it says if you're convicted of this crime by a jury, you do this. Or even in this case, if we knew he was convicted of committing the offense with a deadly weapon, if a jury had made that finding, we'd be in a different situation. Yeah, the real complaint here is that a judge had to make this finding that based on the jury verdict in this case, Mr. Charles would not be required to register. And so I did address this with the idea of and so did the Court of Appeals in Chambers and the Court of Appeals in Charles, addressed this assuming that Myers is punishment. If the court is of the opinion that that's a point that needs to be addressed, I guess I would ask maybe that we would have additional briefing on that, because I have not had the opportunity to fully brief, and particularly to fully brief the way the statute exists now and all of its onerous requirements, and be able to compare that to what was decided by the United States Supreme Court.
The punishment question, in other words.
Yeah, I've assumed by Myers and Chambers and the cases that found it, and in fact the Court of Appeals in this case found it's punishment. They just said that under Carr, under Chambers, which relies on Carr, Beasley, and Garcia, that it's not subject to apprehending.
Any further questions of counsel?
Thank you.
Thank you, counsel.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I'll also primarily be speaking about issue 1 today. Just a couple of brief comments on one or two of the other issues. With respect to issue 2, obviously this court is aware of its own case law, and since this case was briefed, this court has decided that this was not an alternative means situation in this case. So I think that issue is largely resolved by case law that's been passed down since the briefing in this case. I'd also note on issue 4 that counsel is correct that the limiting instruction issue has had a recent change in the case law. So I acknowledge that. I would note, however, that with respect to that issue, the state's argument would be that in this particular case, it still is questionable about whether this issue is properly before the court, because I think that while addressed or attempted to be addressed as an instructional issue by the defense has never told us in brief what the limiting instruction should have said. And this court does have case law, Rojas Marcelino, I believe, is the case, where where this court essentially said that when the defendant doesn't tell the court what the proposed instruction should have read or indicate how the instruction should have been given, that in that situation it's still, in many situations, would still be an evidentiary claim disguised as an instructional issue. So I would point that out, but to the extent this court disagrees with that and finds that the issue is properly before the court, we would just respectfully argue that the evidence at issue in this case wasn't truly 455 evidence, that it wasn't evidence related to a crime or a civil wrong that occurred on another specified occasion, that rather it was a statement that occurred at the same time as the charged offense, and in fact it might actually have been the exact same statement that formed the basis for the charged offense. So that was just briefly something that I wanted to touch on with respect to issue 4. With respect to issue 1, the standard review is clearly erroneous. And first, as I argued in my brief, and the Court of Appeals did not even mention this for reasons I'm not sure about, but as I argued in the brief, the state's first position is that it has to matter in this situation that what we're looking at, is a lesser offense, rather than a situation where the instruction was on the charged offense and the language was different than it was in the complaint or the charging document. A lesser offense is always going to differ in some ways than the charged offense. If they had absolutely no difference between them, they wouldn't be considered a greater or a lesser offense. And my question to
But it
this...
can't be an included offense, can it? If it includes a completely different element?
Yeah, it is a
It's
lesser...
the included place that falls down, isn't it?
Well, yeah, in this situation, based on the statutes or the subsections at issue, it's a lesser degree of the same crime. But I would argue that it would be... I guess what I struggle with is how is the state, how can the charging document ever anticipate or include every potential lesser offense that the district court is ultimately elects to instruct on? There will always be a difference between the language in the complaint and the language in the instructions on a lesser offense.
But what Justice Beyer is saying, when you have an offense with different elements, you can't pick the elements on the principal and then different elements on the lesser and call it a lesser included.
Well, and again, I'm not arguing that this is a lesser. I'm arguing it is a lesser degree of the same offense. But I think my argument remains the same and is still valid in that in this situation, when you look at the case law that tells us in general that Trotloff and some of the other cases that deal with this issue, they've all been, to my knowledge, cases in which the crime that is instructed on is the charged offense. And in that situation, it makes sense to say that the state and the court should be on notice that they shouldn't be expanding the language in the charging document when they're instructing the jury on the very offense that the defendant has been charged with. But in a situation like this, where the offense, it's not the exact same offense. And so to think that the instruction then has to somehow exactly mirror the language in the charging document is where I struggle. I don't think that there's any way. There's always going to be a difference between the language.
I think we're talking about a due process issue here. If you
Well,
charge felony theft for having taking possession from someone, and then a lesser offense on misdemeanor, but say by deception. A misdemeanor theft by deception, you've changed the rules of the game. You've changed the defense, theory of defense.
Well, first of all, I would dispute that it's due process because the defense very clearly chooses to raise it as a clearly erroneous jury instruction. So, to the extent that it wasn't raised by the defense at any point, I would dispute that it's a due process claim. I know that a lot of times the defense will throw that out in an appellate brief.
But we have to decide if instruction is legally appropriate, and if it is a due process violation, then it's not legally appropriate, is it?
Well,
when we go through the analysis on instruction errors, we by necessity have to determine if it violates due process, then it's not legally appropriate, is it?
if you reach that conclusion, no, you don't. But it wouldn't be. But this court, I'm not aware of any case law saying that any time a jury instruction argument is raised, that this court has to sua sponte raise and analyze it under a theory that the defense has never.
I don't think that's what my colleague's suggesting. I think you're arguing against a broader principle that he's not suggesting. He's talking about an instruction on the elements of the crime, not just any old instruction.
And if this court chooses to go that route, it's still our position for the other reasons that we've argued in the brief. One other response to that particular line of questioning is as far as the theory of defense issue, and it's changing the theory of defense. And I think this case illustrates that it doesn't always change the theory of defense, and that was what the Court of Appeals found in its opinion. And contrasting this case to some of the cases in which this has been found to be reversible error, I believe one of the cases cited by the Court of Appeals was a case where, because of the change in the language, it very clearly prejudiced the defense, because the defendant at trial had essentially affirmatively admitted to the element of the crime that was subsequently added in the jury instruction. So there it's very easy to tell that that was something that prejudiced the theory of defense. In Trotteloff itself, it was an issue where the Supreme Court reversed because they found that there was only minimal evidence of the elements that were listed in the charging document, whereas there was much greater evidence of the elements or the theory that was added in the jury instruction. Whereas in this case, as the Court of Appeals noted, the defense that the defendant presented at trial was such that if the jury believed it, he would not have been found guilty under either one of these theories. He essentially argued that he slammed on his brakes in an attempt to avoid this collision but was unable to do so, and he also challenged basically the extent of the injuries that she suffered, I believe. That type of defense in this case, and we have to look at what actually happened in order to determine whether this is reversible error in this case, not on what could have happened in a different trial under different facts, but under what actually did happen in this case. There was no prejudice to the theory of defense. It was a consistent defense that covered either one of these two theories, and therefore there was no substantial prejudice. I don't see in the brief that the defendant has ever even tried to identify specific prejudice that did happen in this case. I think he merely hypothesized that there could have been prejudice.
I agree with you. There's some silence in the brief on that point. But wasn't the evidence that he was following very closely in bad weather, in the dark? I mean, all of that happened before the slamming on of the brakes.
Clearly, yes.
That could be reckless conduct, but likely to inflict great bodily harm, couldn't it?
Well, I think, as argued in issue 2 of the brief, the state's position obviously was, at the time we briefed this, it was under the impression that these were alternative means, and our position was that there was evidence to support either one of these means of the crime. So, again, because this court has subsequently decided they're not alternative means, that's no longer necessary analysis for the second issue.
So you can't really turn around and argue the opposite on issue 1, is what I'm saying.
Well, again, I think that the defense has never really set forth any specific prejudice, I guess, is my bottom line argument here. And the way that this trial proceeded and the way that the defendant presented his case, I think that, again, if the jury had believed the theory of defense, he would have been found not guilty under either theory. The verdict suggests that they did not.
Let me ask this, if I have to take several steps here. First one being that, suppose that we find prosecutorial misconduct. And then we look at cumulative error. Our case law has said that we use the highest burden in terms of a cumulative error analysis. So that would mean that you would have to pass the threshold of a constitutional harmless error standard. How does that change your argument on issue 1? Just as a matter of law, the first question would be, how do we reconcile that with the statute that says in an instructional error it's clearly erroneous? In that situation, do we still apply the higher standard, the constitutional harmless error standard? And second, if we do, how do we meet that here?
Well, not surprisingly, I would argue not. I would argue that on issue 1, that the standard is clearly erroneous because that's how it's been raised. I think what you're asking me is a fair question, and I think that if the defense had presented it as a constitutional due process claim, then perhaps this court, that would be the standard that would apply. But I don't think, again, instructional errors are raised quite often.
Can I stop you for a second, because I don't think you're following. Do you want to repeat your question?
Go ahead.
I think what my colleague's trying to get at is that even if it's standing alone a clearly erroneous burden, even if we were to agree with you on that standing alone, if we were to find error in prosecutorial misconduct, and that requires us to apply constitutional harmlessness standard, and then we get to cumulative error, and we say, well, maybe not standing alone on prosecutorial misconduct, but then we get to cumulative, and cumulative requires us to apply the higher burden when we have errors combined. And then how does that fit with that old clearly erroneous, or do we look at a constitutional error at that point on issue number 1? It's very theoretical.
Sure. I think if the court were to go that route, the defense would certainly be closer. I guess I would say to the constitutional route. If you were to find prosecutorial misconduct, which clearly I would argue against in this case. I think that even under the constitutional standard, of course, this would be harmless unless there is a reasonable possibility of a different verdict. And I think that the fact would still remain that based on the theory of defense, as I've already argued on this issue, the way this case was presented and the strength of the evidence that the state presented in conjunction then with the theory of defense, I don't think that even under that more stringent standard that the defendant would be able to show even a reasonable possibility of a different verdict in this case. A lot of the argument that the defense had advanced in its brief, at least, focused on things such as the degree of injury that the victim actually suffered, which of course is not relevant in looking at this situation. We don't have to show great bodily harm occurred. We just have to show that it was possible in this case. And I think that when you look at somebody driving 40 miles an hour on, as we pointed out earlier, snow-packed roads, closely following somebody, striking them with a vehicle, and the defendant himself, in the immediate aftermath of the accident, was unsure whether the victim was even alive or if he had in fact killed her. I think that given the realities of the case, all theoretical discussions aside, based on what actually occurred in this case, our position is that there is no possibility that there would have been a different verdict. So regardless of whether you apply the constitutional standard, our position would ultimately remain the same. I think that we would meet either standard based on the facts of this case and the theory of defense.
You would agree that the prosecutor in closing arguments just can't repeatedly say, I think, and then argue on appeal that that's not trying to comment on the evidence, personally comment on the evidence.
If the prosecutor were to do that without any reference to the evidence, that would clearly be improper. If a prosecutor just got up and said, I think he's guilty, I think you should find this, I think you should find that, I would not be up here arguing that that's appropriate. But in this case, what happened was that the prosecutor consistently referred to the evidence, and as I argued in the brief, it becomes fairly clear when looking at everything in context that the I think language was simply a rhetorical device, and it's hard for me, it's hard for anybody arguing before the appellate court, and I know it's hard for our trial attorneys sometimes to not slip into using I think or I believe. Obviously what matters is what the evidence shows, but sometimes it's common speech, it's common usage, and as long as it is surrounded by an ample discussion of the evidence, which happened in this case, I would argue that it was not improper in any way. It was just a common usage of the phrase "I think."
It's not even really a rhetorical device. It reads like a verbal tick to me.
And that might be another fair way
Like
to
somebody else goes,
characterize it.
or regrettably, like.
Exactly. And while those are either interpretation would be something that the prosecutor would clearly do better to avoid, and maybe be a more effective advocate if he or she doesn't do that at all. The question isn't whether this was the most effective closing argument in the history of mankind. It's whether it was misconduct based on improper personal opinion. And reading the transcript in its entirety with all the references to the evidence, I would submit that the court cannot make that finding. And I think the Court of Appeals very, very clearly agreed with that interpretation, noting the evidentiary references throughout closing arguments.
Counsel, I see you're out of time, but we've taken up a lot of your time with questions. Would you like 30 seconds to wrap up?
Thank you, Your Honor. I think that I've made all the arguments that I intended to make with respect to Issue 1, and I've noted on Issues 2 and 4 the new case law. I don't feel that I have anything to add that would be especially helpful on Issue 5. I think that the Court of Appeals opinions on this matter have been well written.
Can I ask you about Issue 5?
Sure.
Did the court order that the defendant register during sentencing? Was that part of the court's sentencing order?
You're asking whether it happened in open court or whether it was something that just appeared on the journal entry?
I'm asking whether as part of the sentencing, the court says you're ordered to register as under Cora.
I don't recall the exact language. It was, to my recollection, it was something that was done in open court. I don't recall if the court used the phrase "I'm ordering you" or if the court simply notified the defendant of the duty to register. But I do think it happened in open court. It wasn't something that just appeared on the journal entry.
And the only reason that he had to register under Cora is because the court made a finding that he used a deadly weapon.
Correct.
Okay. And so my question is, why isn't that punitive? If the sentencing court makes a factual determination that requires registration where it wouldn't have been required otherwise, why isn't that a part of the punishment?
Well, this is where the Court of Appeals case law distinguishes between punishment and sentencing, and whether it's only a violation of Apprendi in situations where it increases the sentence rather than increasing the punishment in a more broader sense. And I believe that the Court of Appeals case law has consistently held that something that simply increases punishment but not the sentence simply is not a violation of Apprendi. And I know that within the past few months we have briefed our office has briefed a number of these cases dealing with Cora, where this issue has been fully fleshed out. Just looking at the case law there, and both from this court and the United States Supreme Court, there does seem to be a clear distinction between sentencing and punishment. And in this case, our argument is that it did not increase the defendant's sentence. It was something much like in the cases that we've cited in the brief and that the Court of Appeals relied upon. It was something that simply increased a punishment, but not a sentence.
So punishment isn't the key. Sentence, term of years. If it either lengthens it on the high end or on the low end, that's an Alleyne issue.
That would be the state's position, yes.
Okay, so
Yeah.
when your opposing counsel suggested that you'd like additional briefing on the punishment issue, you're saying it has to go beyond punishment, it has to be the sentence itself.
That is what the state has consistently been arguing in these cases, and that is what I would submit, Your Honor.
I have one further question.
Sure.
And maybe just to have you admit there's some irony in this issue when you juxtapose it with issue number one. Had there been no instruction about recklessly likely to expose someone to bodily harm or great bodily harm, if it had stuck with the wording of the charge, then we wouldn't have any question that the jury found that he used a deadly weapon, would we?
It's an interesting question. I don't know that I'm 100% certain on this answer, although I think that there might be case law indicating, I think that I've perhaps had this issue come up in another case, and the result has been that even there, the district court is ultimately the one that has to make the finding at the time of sentencing, even if the jury, even in crimes where the nature of the offense requires the jury to find that element. I know that the Court of Appeals at least one time has shot me down on that argument and said that for sentencing purposes, that it is the district court still has the duty to do that, even if the charge itself.
It's inherent in the charge.
Exactly, yes,
Not
yes.
sure I agree with you. Okay, thanks.
If there are no further questions, we would respectfully request that the decision of the district court and the defendant's convictions be affirmed.
Any further questions? Thank you, counsel.
Thank you.
Reserve 3 minutes for rebuttal.
Justice Johnson, I just wanted to, since I had the record available, I just wanted to answer the question that it was in sentencing, volume 12, pages 29 and 30. Judge Kaufman noted pursuant to 4902, I do find that Mr. Charles was convicted of a person felony, and I make a finding on the record that a deadly weapon was used in the commission of the person felony, that being the car. As such, Mr. Charles is subject to the Kansas Offender Registration Act. I think Judge Kaufman recognized that based on the instruction given and what Mr. Charles was convicted of, that verdict was not sufficient, and therefore made the additional finding that made him subject to the registration requirements.
The other question about punishment versus sentence, would you like to address that?
Yes. I think that my answer to that is the United States Supreme Court has shown that that's not true, that increased fines, which are not part of a prison number of months of prison sentence, but increased fines trigger the Apprendi requirement. The right analysis, as we said on our brief from Apprendi, is there increased punishment. And even Apprendi recognizes that stigmatization, I knew I would have trouble, stigmatization that stems from criminal convictions is part of that punishment. It's the same stigmatization that you were talking about in Myers, even if that's been talked about separately as a part of ex post facto law.
Do you know if it was argued whether the vehicle was a deadly weapon, or did the court just make the finding?
At sentencing?
Yes.
I didn't review that far,
That's
but I know that the court did.
What I'm curious of is how, and again, I know this is a problem when these cases get remanded back under Apprendi, but I'm having difficulty envisioning how this would happen in front of a jury. The state would argue that the vehicle in this case is a deadly weapon, and the defendant would argue that it's not.
Well, as Justice Breyer noted, one, you could set it out and say, do you unanimously agree that this was done with a deadly weapon? We don't have that in this case.
Right, I understand. Okay.
That could have been set out. Or if that was, since it was all that was charged, if that was all that was instructed on, you may be able to glean that there was a jury finding on that fact, beyond a reasonable doubt.
On issue one, you have focused on the death or likely to cause death element of the lesser. But wouldn't the same argument apply to the change of the mens rea from an intentional act to a reckless act?
I'm not.
Isn't that broad? Doesn't changing the charge from an intentional act to a lesser included that's a reckless broaden the crime that was charged?
But that's included. I mean, we understand or at least after McCarley, we understand that, for example, reckless behavior is included in intentional behavior.
But all the mens rea elements have been just taken for granted as lesser included offenses. I mean, the classic example is felony murder. I mean, not a lesser, but as an alternative that we can define. But those, to me, broaden it. And so from a due process standpoint, how does that different than what you're arguing on the bodily harm or the deadly weapon kind of aspect of it?
Okay. Yes. Clearly, every time you go to a lesser, you're broadening the kind of things that can be brought in within the conviction.
punishable conduct.
Yeah. Additional elements always narrow the kind of things. When you go from second degree murder to first degree, you're always narrowing that. The problem in this case is that it's not just going from narrower to broader, it's going from narrower to broader to something that's not even charged. That's the due process problem in this case.
And what would distinguish it from charging any other lessers? In general, just a general.
Yeah. You would just have to look at what was charged and say, what is fairly included under this charge? What facts have been alleged under this charge? In this case, the use of a deadly weapon. And my colleague suggests that our theory, this didn't have anything to do with our theory, but look at the requested instructions in this case. Mr. Charles was charged with intentional battery by use of a deadly weapon. He requested simple battery and not guilty on the verdict. That was his request. Through the instructions, one place we might look for evidence of a theory of defense, it was Mr. Charles' theory that this was not being used as a deadly weapon. Because that's what he was on notice of. That's what the complaint charged.
But why is he not on notice of everything within a lesser included offense?
Of every different kind.
Every different kind.
Well, you've never said that just because I've been charged with a greater offense of one specific subsection, that then I'm also charged with all the other subsections. In fact, you've said quite the difference, really, if you look at cases like Dixon and Bobby Johnson and things like that, where you said these things aren't lesser included offenses.
But if it's a lesser degree, if it falls within the subsection of the statute that makes it a lesser degree of the charged crime.
Of the charged crime.
Does that make a
difference? The charged crime in this case is intentional battery by use of a deadly weapon.
And so you're saying this is not a lesser severity level of that charged crime?
Yeah, that's what I'm saying. As charged, that it expanded it, just like in Troutloff. That's why it was a problem in Troutloff. If you're correct, Troutloff was wrong, I think.
Any further questions?
Thank you, Your Honor.
Counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.